May I seek your lordship's kind indulgence to mention a writ appeal, which was to be listed today, but it's not listed today. It's likely to be listed next Monday. Next Monday, it's very difficult for me to come from Delhi. So I'm humbly praying that let it be on 30th June.
On
30th June, 30
okay.
June.
This is my lord's judgment, that's why it was not listed.
Yes. Okay. Okay.
30th. Great. Ah, 30th is working. Great.
No, yeah,
30th June is working.
it's a working day.
Great.
Great, please. But, this is a appeal,
Yes.
my lord,
Yes.
against the my lord interim judgment dated 26/3/2030.
But service is yet to be completed in respect of respondent number 2.
Yes, I'm appearing for it. You will be appearing. Yes.
You are paid.
Yes.
Okay. So ready to argue the matter?
My lord.
Are you ready to argue the
My
matter?
lord, so far, my, this IA is concerned because for final, well, these paper books may be required. It's yet to be prepared.
Paper book is yet to be prepared.
My lord. Basically, for my-
Heard Mr. Arsonar, learned counsel for the petitioner, no appellant, and Mr. Learned PP for the state respondent number 1 and Mr. Jiru, learned counsel for the respondent number 2. It is submitted at the bar that service already completed and the LCR has also been received. And accordingly, it is provided that Resi shall prepare the paper book and list the matter after 4 weeks.
my lord, so far, main criminal appeal is considered, it can be after weeks. My lord. This,
After it?
I have a, my IA may be considered
Today.
suspension for sentence.
No, LCR has already been received. Respondent entered appearance. We will finally hear the matter.
Yes, sir.
Then
After a week or after 2 weeks.
after a week, my lord, then, well, can it be on then on my 18th of this month? My
18th.
my-
Okay. Prepare paperwork and list the matter on 18th of June along with the IA number 40 AP 2025.
Please, my lord. My lord, here the judgment of the learned single judge in WPC 279 is put under challenge. Whereby the petition was dismissed for delay.
So what are the grounds?
No, my lord, in the judgment itself, my lord, that firstly, the factual finding is also wrong. And secondly, that the judgments that have been relied upon to dismiss my writ petition, in fact, it is in my favor. Because my lord knows, my lord, belated approach in service, my lord. Generally, there's an exception, my lord. That exception is that where it's a continuing wrong, my lord. And but to deny that, my lord, exception also, there is an exception that where third party rights are being affected. Like I'm challenging someone's seniority, etc. In this case, my lord, I'm retiring in few months only, not even 1 year. I'm not even claiming for seniority also, my lord. But the manner in which I have been picked up and posted in given appointment in some other post, my lord, without any opportunity, my lord. Until that, my lord, from
No.
that, my lord,
That's why the learned single judge
my lord.
observe in the judgment that you have approached the court of belated status.
Of course, my lord, there is some delay that I
Then-
also admit, my lord. But my lord, what the grounds of the petitioner is that, my lord? By delay itself, my lord, it does not extinguish my fundamental rights, my lord. Here is a case, my lord, we have been just picked up randomly, my lord, and placed in a post, my lord, where till date, my lord, no recruitment rules is there, my lord. Nothing, no promotional scope, my lord. I'm still getting the pay of my initial grade pay of the initial appointment also, my lord. I was appointed in 1989, my lord. Whereas all my juniors, since we were posted in some other place, my lord, given appointment in some other post, my lord. My juniors are also all promoted, my lord. And from the post of that AFA junior to senior, they have the scope of going to up to promotion till the horticulture development officer also. We were picked up and posted, my lord, appointed in a post, my lord, where there is nothing, my lord. Till that, no recruitment rules is made, my lord. There's no promotional scope, nothing, my lord. Our service conditions have been, my lord, altered, my lord. That is my case. And our pleaded case is that, my lord, we are not challenging anybody's seniority, my lord.
Yes, Mr. Parme?
And sorry to interrupt, my lord. There is one more aspect where we have said, my lord. The persons holding same post, my lord, in other districts are getting higher pay than me, my lord. Which of course, the department said is a clerical error. There's some error in the other districts, my lord. But I'm getting pay, the department, the same persons in the same post in other districts are getting higher pay. They are getting the pay of the AFA senior, where I'm still getting paid pay of the AFA junior. I was appointed in 1989. I'm still in the same scale, man. Just picked up and
Okay. Yes, Parme?
No, that issue, my lord, two issue, my lord, we have explained in our epidemic, my lord. Epidemic opposition, my lord. When petitioner joined as AMI, my lord, that was a promotional post, my lord, at that point of time, my lord, when they availed that post, my lord. Now, of course, my lord, this pay disparity is there, my lord. You did not enhance, my lord. At page number 74, my lord, or 97, my lord, we have explained, my lord.
Page number?
78, 97, my lord, at para 6, my lord. This is part of our epidemic opposition, in epidemic in opposition, my lord. Para 6, my lord. This was equivalent to AFA senior, my lord, promotional, their promotional post, my lord, at that point of time, my lord. About the issue, my lord, some other equivalent, my lord, person holding the same post getting higher pay, my lord, that we explained in para 15, my lord, page number 99, my lord.
So how this issue was dealt with by the single judge, learned single judge?
those issues, my lord, nothing was addressed to, my lord. The only ground of the dismissal is that there's a debilitated approach and it might affect third party rights, my lord. That was the finding, man, basically. And factual finding,
Mm. 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 What was your pair before the learned single just?
my lord, of course, my prayer was for setting aside my that order by which I was appointed to the post of AMI.
Mm.
That was my prayer, my lord. And of course, I have also prayed for promotion also, my lord. Here, my pleaded case, my lord, the pleaded case of the petitioners are that they are not claiming any seniority, my lord. They just want some pay, my lord. Because it's very ironical, my lord. The scale in which I was appointed in, I will be retiring in that scale, my lord. Same scale, my lord. And of course, the petitioners, they have said that we have accepted it without any
So
murmur, my
whether
lord.
any pair was made in the writ petition
My lord,
to that effect?
my lord,
Whether any pair was made in the writ petition to that effect?
beg your pardon, my lord.
Whether any pair was there in your writ petition to that effect?
Yes, my lord.
Where?
No, my lord, that prayer, my lord, my prayers are basically two, my lord, main prayers, my lord. But of course, this the read course, my lord, of course, they can always mold the prayer. But my
That's
case,
all
my
right,
lord,
but unless you prayed for,
my lord.
why the learned single judge will grant you such a relief?
Well, my prayer is that my appointment order to the post of AMI, my lord, it should be quashed, my lord, and I should be promoted to the post of my lord AFA senior.
Art Mr. D. Soki, learned counsel for the appellant, and Mr. L. Parme, learned standing counsel for the respondent,
1 and 2.
1 and 2. 3. 3 is also district agricultural officer.
Oh, 3 also, my lord. Sorry, my lord, 3
The
also.
intercourt appeal is directed against the judgment and order dated 7/4/2025 passed by the learned single judge in WBC number 279 of 2024. It is to be noted here that by the judgment and order dated so the learned single judge has dismissed the writ petition filed by the petitioner, filed by the appellant hearing. Perhaps the manner of appeal and the grounds mentioned therein, and also perhaps the interim judgment and order, the interim judgment dated 7/4/2025. Admit. Call for the record. List the matter for hearing. After 2 weeks. After 2 weeks.
Okay.
Problem.
My lord, here, the matters regarding construction of community hall at Kurukumi district at CD block, Parsiparlo.
But the service in respect of respondent number 10 to 17.
That is,
yet to
my
be
lord,
completed.
my lord, that is to the private respondent. Here, the honorable court has already observed an two order. Earlier order dated, order dated 08/04/2025, wherein it was specifically made in the para 8 of the order. The Joint Director Rural Development Department, respondent number 6, shall conduct an inquiry regarding the site of the proposed construction of the community hall coming up under CD block, Parsiparlo, Kurukumi district, and the report of his inquiry along with the original geotech site shall be provided to the Learned Standing Council in seal cover for the perusal of the court. And the other point, in the para number 11, it is said the respondent are put to the notice in the event the site where the construction is carried out does not match the DPR. The respondent number 6 shall file his response by the way of affidavit as to why the order should not be passed for stay of the ongoing work. That was one order. And the second order, after that, second order was passed on 14 May 2025. That was again, it was said on the next date, the aspect of the payment again said some other record has to be brought on the before the court. On the next day, aspect of the payment made and pending bills are also to be brought on the record. This was the order, last order that was passed on the 14 May 2025. And so far, no inquiry report has been submitted. And today they are whether they have submitted the amount of payment already payment made or pendings has been not. And the construction, the basic issue was whether the geotech, they have constructed the community hall.
Mr.
the-
Pisa, where is
Yes, ma'am.
your affidavit?
My lord, we need some time. Only yesterday I have received the comments, my lord, not paragraphs, only comments, my lord. And regarding that, my lord, report, my lord, on last occasion also we have submitted, my lord. The joint director, my lord, who was designated to make an inquiry, my lord, he had a, my lord, neck surgery. He is has a neck surgery in the back, my lord, and he carries 2 platinum pin, my lord. So it is difficult for him to make a journey, my lord. So we requested this honorable court to direct the deputy commissioner, my lord, who would be the competent authority, my lord.
In the meantime, other authority can also assist. So if the one authority is finding some difficulties, they should entrust other authority to do the needful. At least they can put the at least he can read the verification report and put the signature on the report. So this is just nothing but a lingering technique. And this has been since long days. And because DPR, the construction of the community hall has been not made as per the DPR basic issues, and they have made at far distance of the original geotech. This is the main issues. Correct cases. This is the case. That is why the PIL was filed.
Well, I have taken that instruction also.
And
What happened,
It's
my lord?
not a huge amount of money, around 12 crores.
It's not,
So
my
it's-
lord, taking
and
away
this-
the place from
The
where the
PIL
geotech was
filed
done.
long
The
since
problem is,
they failed to submit the report. And in spite of giving the order by the honorable court on 14 May 2025, and today also they have not, even they have not submitted the how much quantum of the bill has been already paid or how much is remaining. That also has been not submitted. And any other authority can submit the same. It's not necessarily required that the respondent number 6, who is under surgery or whatever, maybe under medical condition, to do the needful. All the authority are concerned to here. They must prepare and submit before the honorable court as per the direction of the honorable high court. So this is the situation. So in this situation,
Yes, my lord.
if they are seeking time,
If he let me
Yeah.
speak, then.
if they are seeking time,
No,
the pending bill should be stayed and ongoing work also should be stayed. So how much time they want to take, let them take. Otherwise, they are taking advantage of the situation and just time buying the time.
Let him file his affidavit.
Till then, my lord, please,
Thereafter we'll hear him.
uh,
Then, you take step up on the rest of the respondent.
yes,
Then
my
you
lord.
will
Yes,
file it.
yes. All the private responsibility step has been
Learned
taken.
Learned counsel for the petitioner and Mr. Lisa. Learned standing counsel for the respondent number
25678.
25678 and madam
1, 3, and 4 yellow.
1, 3 and 4.
10 to 17 are private respondent.
Office note dated 31/5/2025 indicates that service report in respect of respondent number 10 through 17 is still awaited.
They are private respondent. Private contractor, they are private respondent.
So that's all right.
Mm.
You have to take step upon.
Yes, yes, yes. I have taken a step. So repetition is step is not required, I think. It is for them to respond. I have done my duties. It's just awaited.
List the matter. After 2 weeks, awaiting service report upon respondent number 10 to 17. Mr. Pisa, learned standing counsel for the respondent number so and so submits that he may be granted 2 weeks time to file the affidavit in opposition. Fair is accordingly allowed.
My lord, one small prayer. In this, till such period, no further payment may be made. One observation may be made, please. Otherwise, very purpose of PI will be diminished.
Let his affidavit come.
Yes.
Only thereafter.
If all the
Till-
bill
till
has
date,
been,
extra copy has not been furnished to us, my lord.
many times I have furnished, now also, instantly
I
I can furnish.
have said my original copy, my lord. This is the amended copy, my lord.
Counsel for the respondent number so and so. So submits that he has not been furnished with the extra copy of the requisition. Mr. Nebo undertakes to furnish the same during the course of the day.
My lord, it's very logical. Till such period, no payment, only for 2 weeks,
Let the affidavit.
only for such
Will
period,
come
no
with-
payment. If they are just techniques applying just to withdraw the amount illegally, that's whatever has been made.
My lord, we will come with his private interest, my lord. What is the private interest of
Let the
the petitioner?
affidavit come.
Yes, ma'am. Obviously.
Next.
Made Pujala. My lord, initially the learned single judge passed an stay order against which we filed the appeal. Now, in the appeal, there is an interim order, and pursuant to the interim order, my lord, we have executed the agreement. Now, I think, my lord, the writ appeal can be closed. Let the learned single judge decide the writ petition, and the interim order will be made absolute, and it will be subject to the outcome of the writ petition. Because, my lord, this interim order was passed on 2/4/25. Then on 4/4/25, in terms of the order, we submitted the undertaking to the Ministry of Coal. Then we also filed an undertaking before this honorable court that we will abide by further orders to be passed. And on 9/4/25, the agreement was also signed. So therefore, now there is a contract between the appellant and the Millard department. So possibly now in the writ petition, they have to put to challenge all this, Millard. Anyway, Millard, this writ appeal can be closed by saying that interim order will continue till disposal of the writ petition. The order dated 2/4/25.
Otherwise, my lord, what respected senior counsel has submitted, my lord, is true. And the order was passed, my lord, the lighter side. Order is like this, my lord, divorce petition is pending. You can remarry subject to outcome of divorce petition, my lord. So they have given undertaking that subject to outcome of writ petition. In the meantime, my lord, agreement has been executed, everything. But I don't think, my lord, my senior is correct, my lord. Let the writ petition be disposed of, my lord. And so far as this interim order, my lord,
Finally, the matter has to be
Decided by the learned
learned
single
judge.
learned single judge.
We are only against the interim order.
Because undertaking was given by them that whatever will be the outcome of writ petition, they will abide by
Yes,
that.
yes. And order dated 2/4 is very clear, Millard. Passed in the writ appeal.
Para 5 and 6.
Mr. Chaudhary, you have a copy of that order?
I have.
Yes, yes.
but it is marked. Para 5 and 6 months.
Only order to. Huh? Yeah, I know. Yeah, no?
In IA.
Yes, IA 90 of 2025, that order is.
Part
Yeah.
in IA.
Who said? You. You are in one is putting it order.
And
এখন হেভি হে আই অর্ডার টু কোড
one IA is for leave, another is
my lord, the order is in IA 90 of 25. Yes. Is there?
I have given your lordship copy of.
Para 5. It is however submitted in that in the event the court is inclined to modify the interim order, applicant would give an undertaking that he will not be aggrieved if any adverse orders that are passed against the applicant in the concerned appeal, even if the work is awarded to dispensary.
Yeah. This copy, this order is not, it is there. but
Yes. So para 6 is the operative portion, my lord. Having noticed that no reason has been assigned in the order dated 17/3/25 passed in WPC as to why tender process should not be finalized without leave of the court, and that the court has not recorded its prima facie satisfaction with the entitlement of the petitioner for granting interim relief, this court is inclined to stay the operation of the interim order dated passed in WPC number so and so. Accordingly, there shall be no bar for the authorities to finalize the tender process without leave of the court. However, this stay is made conditional by providing that finalization of the tender process shall be subject to the outcome of the litigation. So this is the portion. So by maintaining this, my lord, the writ appeal can be closed. Too much of clarifications.
Yeah.
His lordships has that civil background, my lord.
Heard Mr. Ken Sober, learned senior counsel for the FLN. And Mr. A. Goyal for the
Respondent number 3.
respondent number 3, and Mr.
Mother, I put the reference as 1 and 2.
Mr. Kato for respondent number 1 and
2.
1 and 2. And you? 3. Okay. This appeal under chapter 5 of the Guwahati High Court rules is directed against the interim order dated 17/3/2025 passed in WPC number 109 AP of 2025. It is to be noted here that by order dated so the learned single voice. Has state the concern.
Not stay, my lord.
Directed that the concerned tender process shall not be finalized without the leave of the court. Without the leave of the court. Mr. Ken Surri, learned senior counsel for the appellant submits that the appellant has also preferred one IA, being IA civil 90 AP 2025. Where this court was placed to stay of the operation of the order dated 73/2025 passed by the learned single judge in WPC number 109 AP 2025. And further, Mr. Chaudhary submits that this appeal may be closed. may be closed. And the matter may be relegated to the learned single judge to decide the WPC number 109 AP 2025. Until then, the interim stay may be allowed to continue. Any objection, Mr. Akbar?
I have no objection. If your lordship clarified that state the order was modified subject to certain condition, that may be reflected in the order.
That you follow.
Your lordship has said that it is stayed, but
Yes.
it was stayed subject to certain conditions, madam. That may be
Paragraph 6.
Paragraph 6, that may be quoted, madam. That may be, because they have given undertaking,
That we have filed, that affidavit we have filed.
only that much. Otherwise, I have no objection.
Or lordship may say this stay was made conditional by providing that
Yes.
finalization shall be subject to the outcome of the, that will take care of everything.
Mr. Goel, learned counsel for the respondent number 3, submits that he has no objection, provided the condition laid in the paragraph number 6 of the interim order dated in the order dated 2/4/2025 in the IN number 90 AP of 2025 is fulfilled. But having heard the submission of learned counsel for both the parties, we have carefully gone to the appeal, memo of appeal, and also the grounds mentioned therein, and also the order dated 2/4/2025. It is to be noted here that in the order dated 2/4/2025, the learned, this court was placed to observe as under 6. But taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to close this appeal by directing the learned single judge to dispose of the writ petition. And till disposal of the writ petition, the interim stay granted by the order that is shown so shall continue.
Deep, madam. Deep.
My lord, before my friend starts, my lord, this item number 5 is a transfer matter. I've been asked to produce the record, my lord. I'm sorry, my lord, record is not available. Can this matter be taken up Thursday, my lord?
On
Thursday, this Thursday, my lord.
third zone.
Thursday, my lord. We are on Monday, my lord.
Lordship, may I submit, Lordship? Lordship, the issue here is, the appellant herein, he is on the verge of retirement, Lordship.
No, all right, there is a judicial order.
And
to
in
produce
fact,
the record, my lord. I'm sorry for that.
this single bench, Lordship, learned single bench order, Lordship, that has even the learned division bench has
Tell
observed.
me whether without record we can hear the matter.
Lordship, record, that record is already in the affidavit in opposition filed by the respondent authority, Lordship. Everything is there, Lordship.
Yes.
So then,
Records means, my lord, file noting how, my lord, transfer posting started, my lord. The vacancies, all this.
So there is specific direction of this court to obtain the record.
Correct,
Lordship,
correct.
Let him produce the record on Thursday.
Thursday, my lord.
Lordship. Edit target,
Thursday means your first tarikh. Okay. Any other day?
Lordship, 5.
Fine.
Friday.
Thursday, my
Thursday,
lord,
Thursday.
Okay. Heard Mr.
8 attack, Lordship.
Learned counsel for the appellant and Mr. R.S. Nabar, learned
Train club, also like this. Train club.
additional lazy. And Mr.
Arriba, my lord, for private respondent number 3.
For private respondent number 5. Mr. Nabam submits that though this court was placed to direct him to produce the record, but he could not obtain the record and he tries for listing the matter on Thursday. Where it's allowed, let's list the matter on Thursday.
Deeply obliged.
Lordship.
Item number
16 to 19. These are connected matters, Lordship, and I am for the petitioner, Lordship. Lordship, this matter may be taken up after 2 weeks. I have
After?
informed the other side also.
after
2 weeks.
2 weeks.
Yes, Lordship. I have informed the other side also.
Mr. Your good name,
K lawyer.
learned counsel for the petitioner with concern from the other side, press for listing the matter after 2 weeks.
2 weeks.
Fair enough.
Highly obliged.
Well, Lordship. Lordship, I would like to mention item 9 and 10, Lordship.
Item number 9 and 10.
9 and 10. Lordship, I have to file Lordship short rejoinder affidavit, Lordship. 2 weeks maybe give. 2 weeks
Okay.
time.
Mr. Your good name,
Elbam, Lordship, for the
learned
petitioner.
counsel for the petitioner.
Yes, sir.
With consent from the other side, press for listing the matter after 2 weeks.
2 weeks.
After 2 weeks. Fair enough.
I am appearing for the respondent.
Respondent. Mr. Your good name,
PK code.
learned counsel for the respondent.
Okay.
Please, your lordship. Lordship, this is a contempt, my lord, against the order dated 10/4/2025. The operative portion of the order is at page 150, 150, my lord. It's because of the memo of parties, that's why it's long. It starts at page 148. The operative portion, lordship, will find at 150.
Yes,
My lord, will see from it is ordered that. It begins in the previous page, but from it is ordered that lordship may read. It is ordered that actually, before actually taking over the land for the construction work, the respondent authorities will videograph the entire stretch of land which will be taken over so that the land could be identified. In this regard, the concerned authorities shall also ensure that the process of land acquisition, which includes disbursement of land acquisition compensation, the provisions of section 11 and 12 of the Right to Fair Compensation, the Land Acquisition Act 2013, shall be scrupulously adhered to. Moreover, videography of the entire stretch of land shall be concluded before actual taking over of the land so that the nature of the land, existence of zirats, if any, and assets, if any, thereof could be captured. Insofar as the disbursement of compensation is concerned, the respondent authorities, especially the Deputy Commissioner Kurungkumei District, before disbursing the compensation, shall make public the joint verification report in respect of the land in the 3 stretches of frontier highway and the field survey report as envisaged in the minutes of the board meeting dated 27/4/2025 shall also be produced before the court on the next date of specifically detailing the names of the persons whose lands are proposed to be utilized for the frontier highway. My lord, this is an order of 10th of April. My lord, there is a format, if my lord comes to page 154, this is the format as per the Arunachal Pradesh Land Acquisition Manual. My lord, where the signatures of the landowners are to be taken. If lordship sees page 154, there's a tick mark lordship will see on the right-hand side. This is the format which is to be filled up in the survey. Now, this was not done, my lord. The petitioners, landowners, they were not there during the survey. There was no survey actually contemplated and actually held. It was for only, lordship, this is a stretch of 135 kilometers of highway. The survey was purportedly done before this order passed by this honorable court, my lord, on 3 days. In 3 days, it is not at all humanly possible, my lord, to cover and, my lord, survey 135 kilometers for the highway, that too in a hilly terrain. Now, what they did, my lord, if my lord comes to page 155.
page 1.
155, the next page. This is a letter from the Additional Secretary, Land Management to the Deputy Commissioner. It says, with reference to the letter on the subject cited above, I am to inform you that there are some observations on the draft cost estimate as mentioned below. Number 2, lordship may come. The rates of forest item are taken in quantity without giving any details of number of trees, size of trees, timber, diameter, rate of timber are not as per the manual of 2022. Further, density of plantation is not found at visible. Rates of storm structures are not there as per manual, so and so. My lord, this is the same, the contents of this letter are same in the next page, my lord, page 156 and 157, because these are of 3 different stretches. These letters, my lord, are of January 2025. The report which Lordship had seen in the order reflected earlier, my lord, is from page 158. This was the board meeting, which was reflected in the order. Now, what is being done now, my lord, if my lord comes to page 164 or page starts at page 163, this is 19th May 2025. With 19th May 2025, my lord, without conducting any survey as directed by this honorable court, what the Deputy Commissioner has proceeded, my lord, is to finalize the draft. My lord may come to the second paragraph. Whereas the draft award under section 23 of the LAR Act 2013 for the genuine landowners was prepared, which has received due approval from the competent authorities. Therefore, the disbursement board is constituted with the following officers for payment of compensation to the genuine landowners. Now, Lordship may come to the next page. Serial number 1 of the SOP, which is there. The Board of Officers shall publish the approved final award list in their jurisdiction for at least a week before setting a final date for disbursement. My lord, as per the Land Acquisition Act, including the 2013 Act, it is the Deputy Commissioner who has to pass the award. He cannot delegate this authority to someone else. Now, why we are before Lordships by way of this contempt? My lord, there was a clear direction to adhere to section 11 and 12 of the 2013 Act. My lord, to conduct a proper survey. That was the grievance by which we had approached Lordships. Now, that has not been done. What they have done, they have proceeded to finalize the
Okay, let notice go at this.
My lord.
Heard Mr. P.D. Nair, learned counsel for the petition. This application under section 11 and 12 of the Contempt of Court Act 1971, read Article 215 of the Constitution of India and Rule 9 of the Contempt of Court, Guwahati High Court Rules 1977. Is prepared by the applicant for non-compliance of the order of this court dated 10/4/2025. Passed in WPC number 171/18/2025. Here is the petition and the documents plus on record, and also here is the order dated 10/4/2025 passed by this court. That notice be issued to the respondents to contempt.
Soon. One respondent.
By research course with AD and also by usual process, which I wait from today. Please the matter after 2 weeks or 4 weeks.
2 weeks, my lord. 2 weeks. My lord, may I also be permitted to serve by Dusty, my lord?
Okay,
In
the
addition.
service is also permitted.
My lord, deep your May it please your lordship.
My lord, this is a transfer, we're challenging a transfer order, my lord. But please come to the order at page number 24. On 24th of April, my lord, the petitioner, who is the substantive executive engineer, Daporizo Electrical Division, he has been transferred to the office of the chief engineer at Itana. Now, my lord, kindly see first para. Further, N.K. Jha, Daporizo is hereby directed to hand over charge of executive engineer to senior most assistant engineer electrical of Daporizo division. The charge of executive Daporizo is purely on temporary basis, etc. So, my lord, I am an executive engineer. I am supposed to hand over charge to an assistant engineer, not even to an assistant executive engineer. Then my lord will kindly come to the next page, page 25. In pursuance of the transfer and posting of engineer N.K. Jha, white order dated so-and-so of Arunachal Pradesh, Kajan Tamin assistant engineer is hereby directed to take over charge of executive engineer with immediate effect purely on temporary basis till posting of the regular executive engineer or until further orders. Now, my lord, normally what happens, an incumbent hands over charge. So, my lord, the person who will take over charge is normally not directed. That on the same day. And under the financial rule, my lord, everybody has 15 days time. Now, please come to the next page, page 26. On the same date, 28/4/24, this assistant engineer purportedly unilaterally takes over charge. I do not know, my lord, what is that earth-shattering urgency. And this assistant engineer is working in this office for the last 10 years. Now, my lord, kindly see why this transfer order had to be passed. Now, there was an FIR lodged by respondents number 6 and 7, which your lordships will find at page 43. FIR against engineer N.K. Jha for offense under section 7 of the PC Act for demanding and taking bribe of commission of rupees 40,000 from us in lieu of passing our pending bills. It is to inform you, your good office, that today at around 3:47 p.m., the above person who is present executive engineer power department have taken bribe of rupees 40,000, that's 20% of the commission for the work we have done under Giba Circle. Fact of the case is that we both, being unemployed youth of Giba Circle, have once apprised the then executive engineer power department. So considering our condition and prayer on special consideration, the in-charge executive engineer engaged us for electrical work of BSNL. It is the, my lord, that I think possibly is the same person, assistant engineer. Lower at so-and-so for a cost of rupees 2 lakhs each. Okay. That before you could complete our work, above person was posted. Hence, after completion of our work, we reported him about completion of our work. So we asked him to make over payment of our work, but he lingered by saying that for like this or that reason. On our repeated approach, he opened up his mouth by asking 20% of the commission of the total cost for release of the bill. Further, above person have even threatened us to file FIR against me without any reason. So, my lord, the allegation was that they were given 2 works of 2 lakh each, and that for release of the payment, he demanded rupees 40,000. Now, my lord, till that, no FIR has been registered. No case has been registered. Then, my lord, taking cue from the FIR of 6, respondent number 6 and 7, respondents number 8 and 9 also filed a complaint before the authority. Now, my lord, because there was a complaint, therefore an inquiry was instituted, whether the allegations are correct or not. Now, please come to the report at page 48. Before that, if your lordship would kindly come to page 47. Now, this was the chief engineer, Central Electrical Zone. He conducted the inquiry and he submitted the report. Please come to page 47 towards the bottom, my lord. Heading is work execution finding. The execution of electrification work for BSNL tower at Leria, Pute, Langia, and Lucy in Giba Circle under Daporizo Electrical Division deviated significantly from the approved DPR and the work order. So the work, while doing the work, my lord, there was a lot of deviation. The work commenced on verbal instruction from the then executive engineer in charge and was executed as per direction of the junior engineer without proper documentation or adherence to the specification. The work orders were issued only after completion of the work, and discrepancies were found between executed work and the approval. My lord, if there are, my lord, there are deviations in the work, why should I have? I'm not obliged to make the payment, my lord. That's why I was inquiring about all this. That is why the delay caused in payment of the bill. Now, kindly see, my lord, allegations against N.K. Jha. Complainant Sri so-and-so, that is respondent number 6, and Tagam Giba, that is respondent number 7, submitted an FIR alleging that Sri N.K. Jha demanded 40,000 as 20% of the work value as departmental expenses. Audio and video evidence were provided by the complainant. However, NK Jha denied the allegation, claiming the recordings were fabricated and dubbed. Statements from other witnesses, including complainants, junior engineer, assistant engineer, and others were recorded. While there were indications of monetary discussion in audio recording, footage does not explicitly show officer receiving money. I'm reading this line, my lord. The footage does not explicitly show the officer receiving the money. The inquiry committee could not conclusively establish bribery, but recommended for further expert verification of the audio and video evidence to ascertain the authenticity of the allegation. So, my lord, nothing was proved. However, for the ends of justice, my lord, it was felt desirable that forensic opinion should be obtained. Recommendation. Given the gravity of the allegation and inability of the inquiry committee to conclusively verify the authenticity of the provided audio-video evidence, it is recommended that matter be referred for further investigation by an expert forensic team to authenticate the audio and video recording. Based on the forensic finding, necessary disciplinary or legal actions be initiated against the accused officer if found guilty. So, my lord, as of now, there is nothing. So the chief engineer felt that no, there should be further investigation by the forensic experts. And if anything emerges, then departmental observers, other legal measures should be taken. Now, my lord, based on this, then, my lord, I filed a writ petition. Now, this honorable court dealt with this matter at page number 67. At that stage, I approached this honorable court. And this honorable court, my lord, if your lordship should kindly come to page 68, paragraph number 9. After hearing the learned counsel for the parties and considering the decision of the Honorable Apex Court in Somesh Tiwari and the entire aspect of the matter, this writ petition is disposed of at the motion stage itself, directing Secretary to the Department of Power, Government of Arunachal Pradesh, to dispose of the representation of the petitioner dated so-and-so, pending before the authority received by the office on so-and-so, by day dated so-and-so, on or before 16/5/25, intimating the petitioner about the outcome of the same, subject to submission of certified copy of this order along with copy of the writ petition, including annexures, etc., etc., and a copy of the Apex Court in Somesh Tiwari by petitioner on or before so-and-so. Before, anyway, my lord, the direction was that the pending disposal representation should be disposed of. Now, please come to page 69, my lord, para 10. Up to 16/5/25, till disposal of the said representation of the petitioner dated 28/4/25, noted above, impugn transfer order dated 24/4 so-and-so issued on 28 by authorities in Power Department of the state, transferring the petitioner from Daporizo to Office of the Chief Engineer shall not be given effect to, subject to furnishing of so-and-so. So, my lord, this honorable court said, if the representation is disposed of, please don't give effect to the transfer order. Then, my lord, they passed the impugn order, which is at page number 70. Now, I'll have your lordship attention to page 75. So this is the original transfer order, as well as this order, my lord, by which the representation was disposed of, is under challenge in this proceeding. Para 7. Accordingly, the inquiry committee under the chief engineer power was constituted by order dated 27/12/24 to conduct a preliminary inquiry to verify the allegation made against the officer. The inquiry committee conducted the preliminary inquiry and submitted its report to the Undersecretary, Government of Arunachal Pradesh. The committee found allegations to be prima facie correct and recommended regular departmental proceedings similar. Where have the committee said found prima facie? Committee said if upon receipt of forensic report, the findings goes against the petitioner, in which event department would be at liberty to proceed either departmentally and legally, meaning criminally. So, my lord, this premise that the inquiry committee prima facie found the allegations to be correct and recommended for regular departmental proceeding is not correct. This is wrong. So the first premise is wrong. Now please come to the second para. However, it was felt that before initiating regular disciplinary proceeding against the Niranjan Kumar Jha, he should be posted out of his present position of executive engineer Daporizo because his continuance in the said capacity during disciplinary proceeding may not ensure fair and impartial inquiry against him and is also detrimental to good governance. It was under these circumstances that the decision was made to transfer Niranjan Kumar Jha. Now, my lord, lordship will see there are two aspects, my lord. In a criminal case can be said to be pending when a charge sheet is filed, my lord, following completion of the investigation. It is only in that situation that it can be said in view of the law laid down by the Supreme Court in Janaki Raman's case that a criminal case is pending. So in our case, not even any case is registered. FIR was filed, that was there, but no case has been registered. So my lord, when does a departmental proceeding is instituted? When, my lord, a charge memo is issued. So in our case, the forensic expert is yet to give his opinion. Based on that, something may happen, may not happen. So therefore, there is no disciplinary proceeding is pending. There is no criminal proceeding is pending. All that is happening is, my lord, some police investigation in which it is the role of the police. Department has nothing. Therefore, that my continuance in the Daporizo will adversely affect anything is absolutely, my lord, without any foundation. So second premise also goes. Now please come to the third premise. Judgment of the Honorable Supreme Court in Sumesh Tiwari case is considered. In the said case, without conducting a preliminary inquiry to verify the allegation against the official, order of transfer was issued. However, in the present case, preliminary inquiry was conducted against Niranjan Kumar Jha and allegation legal against him were found prima facie to be correct. On the said basis, the inquiry committee recommended initiation of regular departmental proceeding against him. Now, again, reiterating, my lord, preliminary inquiry which was conducted in this case have not found anything. In order to arrive at some finding, my lord, they felt that it is necessary to have the forensic expert's opinion. So on that count, it is wrong, my lord. And second count, in Sumesh Tiwari also there was a preliminary inquiry. Well, Sumesh Tiwari is an authority for the proposition that you are not supposed to transfer somebody based on some allegation. Supreme Court said it is bad. It is unsustainable. It is something like, my lord, if you are taking any action based on some allegation, then the basic rules of natural justice has to be followed, my lord. Be it comes to, my lord, confirming the services of a provisioner, be it comes to taking any action based on some report, then I must be given an opportunity. Otherwise, it will be filed to have natural justice. Now, please have this Sumesh Tiwari's case, my lord. My lord, will kindly come to paragraph 16. My lord, we are challenging the decision-making process. Whether I should be transferred or not, it is entirely in the domain of the authority. That court will not examine. But definitely court will examine the decision-making process, the manner in which the decision has been taken. Please come to para 16. Indisputably, an order of transfer is an administrative order. There cannot be any doubt whatsoever that transfer, which is ordinarily an incident of service, should not be interfered with, save in cases where inter alia malafide on the part of the authority is proved. Malafide is of two kinds: one, malice in fact, and second, malice in law. The order in question would attract the principle of malice in law, as it was not based on any factor germane for passing an order of transfer and based on an irrelevant ground, that is, on the allegation made against the appellant in the anonymous complaint. It is one thing to say that the employer is entitled to pass an order of transfer in administrative exigency, but it is another thing to say that order of transfer is passed by way of or in lieu of punishment. When an order of transfer is passed in lieu of punishment, same is liable to be set aside being wholly illegal. So the proposition of law is, my lord, You are not supposed to transfer me because there is some allegation against me, because that allegation is yet to be proved. So if you do that, then you are taking note of some misconduct on my part. If you are taking note of misconduct, then you are supposed to hear me. Where have you done that? Now, my lord, forensic expert is yet to give their opinion. There is no criminal case. There is no departmental proceeding. And why you are, trying to help out a person who is there for the last 10 years? So therefore, my lord, this is one journey. And secondly, my lord, this gentleman, this respondent number 5, who is not even an assistant executive engineer, he is an assistant engineer. Now, is he a person who is entitled to take over charge from me? The Supreme Court has said in this matter, my lord, 1994 6 SCC 98 NKC. My lord, it's a very famous case, my lord, and it has a long history. Please come to para 9.
Yes.
Transfer of a public servant from a significant post can be prejudicial to public interest only if the transfer was avoidable and successor is not suitable for the post. Now, in this case, my lord, the transfer order was absolutely avoidable because as of now, there is nothing against me. Some bold allegations. And number 2, my lord, I have handed over charge to whom? An assistant engineer. I am an executive engineer. Now, how public interest is going to be served, my lord? So, therefore, I am not questioning the wisdom of the government to transfer me. In administrative exigency, you have that power, and court will not interfere normally. But in a nature of this kind, my lord, where I am sought to be punished because there somebody has alleged something against me, it cannot be permitted. So, therefore, my humble submission is, my lord, Lordship will examine this matter. And my lord will stay this order because what was that earth-shattering urgency? My lord, at least we have not heard it, my lord. I can appreciate, my lord, some heavy projects are going on, some expert is to be inducted. My lord, under the financial rule, I am entitled to 14 days time, 15 days time to hand over charge. Same day, somebody will be directed to take over charge, somebody charge, he files a caveat. What is his interest, my lord, that he is filing a caveat? Unilateral charge. So therefore, my humble submission is an absolute, it's a case of malice in law. Therefore, my lord will state his order pending further proceedings of your lordship. That is my humble submission. Lord, we have not handed over charge as yet.
Yes, I'm well.
Yes.
Before my lord coming to those documents, my lord, if my lord kindly come to page number 24, my lord, this is the transfer order, my lord. Page number 24, my lord, before coming to those. Sorry, my lord.
Yes.
My lord, here, my lord, we see, my lord, in the interest of the public service, the governor of Arunachal Pradesh is pleased to order transfer and posting of such and such as executive engineer planning. Further, such and such is hereby directed handed such executive engineer to senior most engineer, such and such discharge of executive engineer division purely on temporary basis till posting of regular is or until further. I am reading this, my lord, to show that, my lord, this order, my lord, there is no adverse remark, my lord, against this petitioner, my lord. So suggesting that, my lord, this is a punishment or transfer, my lord, is not correct, my lord. This is just a order, my lord, issue in public interest, my lord. The record, my lord, which is so, my lord, that is not before the public domain, my lord. So in such situation, my lord, this transfer order cannot be termed as a punishment transfer, my lord. In public interest, my lord, this was order, my lord. Now I have other ground here, the petitioner projecting, my lord, that, my lord, Only on the basis of allegation of private respondent, some private respondent, my lord, he has been transferred, my lord. That is also not correct, my lord. My lord will kindly have a look at this, my lord. This is official document, my lord, of the his just superior officer, my lord. My lord will kindly have a look at the documents I placed, my lord.
Yes.
This is, my lord, partially, my lord, kindly have a look at order dated 21/1/2025, my lord. May I read this, my lord? It is brought to the notice of the undersigned that the executive engineer, the Project Electric Division, Upper Service has randomly appointed many casual labor without obtaining prior approval from the Superintendent Engineer, AP Electric Circle Report 0, who is violate the guideline of the regulatory scheme of the Department of Power. Now, therefore, the appointment order issued by the executive the Porijo Electric Division with prior approval from the Superintendent Engineer is hereby cancelled, my lord. Now, next, my lord, is order dated 25/3/2025, my lord. Whereas it is brought to the notice of the undersigned that the executive engineer Porijo, Upper 7 District has prudently obtained casual staff exceeding the sanction strength of the Porijo Electric Division, who is violate the continuous order issued by the government of Arunachal Pradesh in time to time. Whereas approval of 15 casual labor under the Porijo Electric Division was already conveyed with such within a sanctioned strength. Whereas the executive engineer deliberately violate the approval conveyed with above mentioned officer letter by appointing more than 15 casual labor, who is against the direction of superior and approving authority. Now, therefore, the executive engineer Upper Secretary is directed to restrict the appointment of casual labor as approved in Para 2 and cancel an order the excess appointment be issued within 3 days from the date of this order and submit the action taken report to the Superintendent Engineer AP Electrical Circle Pipe immediately. If does not comply with this order, the financial implication for excess appointment of casual labor shall be recovering from the officer concerned as per the rule amended time to time. Hence, for the executive. Now, this next, my lord, I have placed on record, my lord, this 7/5/2025, my lord. This is, my lord. Now, situation before department, my lord. A person, my lord, is exercising the official authority, my lord. As a, my lord, authority of his own, my lord. Now, he is appointing beyond the sanction post, my lord. In even about repeated, my lord, warning, my lord, he is continuing the process, my lord. Now, there's allegation of corruption also, my lord. Now, in such a situation, my lord, this my letter 7/5/2025, my lord, I place on record, my lord. This is the SC superintendent, my lord, has written a letter to the chief engineer, my lord, or in last para I am reading, my lord. It is last para. It is observed that the behavior and attitude of such and such, the opponent is indulged in the act of unbecoming of government servant and get involved in unauthorized communication of official documents. Also found habitual negligence of order from the superior. Such action may be initiated against this, my lord. Now, this process, my lord, we have started, my in the process, my lord, in the file process, my lord, not though memorandum of such has not been issued, my lord. Now, my lord, assume a situation, my lord, where public servant, my lord, is acting like, my lord, not complying with the order of superior authority, my lord, not violating every rule and regulation now and then, my lord. Now, in such situation, my lord, when we contemplating disciplinary proceeding, my lord, I humbly believe, my lord, authority, the appropriate authority, my lord, can surely, my lord, issue a transfer order, my lord. It is not a case that he has been punished, my lord. If there had been some adverse remark in this transfer order, my lord, then surely, my lord, that can be termed as a punishment or transfer, my lord. It is not punishment, my lord. Looking into whole those aspects, my lord, as we are a department, my lord, is contemplating a departmental inquiry, my lord. For peer departmental inquiry only, my lord, this he has been transferred, my lord. Now, that has been already considered by the in the now impugn order, my lord, at page number starting from by the secretary, my lord, 73, my lord. Now, what I if I have heard correctly, my lord, the petitioner, my lord, is try, my lord, call upon this call to, my lord, test this order on merit, my lord, as a appellate authority, my lord. I humbly believe, my lord, read court, while exercising, read court cannot test this on the merit, my lord, as a appellate court, my lord. I humbly believe not, my lord. So I find, my lord, in this case, my lord, there is no mala fide, my lord.
No,
No mala fide, my lord. No violation of statutory provision, my lord. Only those two circumstances, my lord, this honorable court, why exercising a writ jurisdiction can interfere, my lord. So I humbly believe, my lord, this is not a case for interference, my lord. Situation, my lord, a person, my lord, who is not favored by the public, my lord, who is not favored by the authority, my lord, how they can be kept in such a responsible post, my lord. In my lord, the EE is very responsible by all the development activity, my lord. It execute in the district through a EE only, my lord. Now, person who is not good in term with the public, good in not term with the, his officer, my lord, keeping that in the responsible post, my lord, will surely prejudice the public interest, my lord. So this transfer order has been issued in the public interest, my lord, and my lord will not interfere with this, my lord. To substantiate my argument, my lord, I am submitting this to citation, my lord. This is the not reading to, I have indicated the para, relevant para, just in the side, my lord. Para, I have indicated in the side, my lord. I am not reading this, my lord. So my humble submission, my lord, may issue can notice, my lord, but not for any interim order, my lord, at this statement. That will surely prejudice the public interest.
I'll have few words only, my lord. I clarify, my lord, at the very outset that respondent 5 has no personal interest in the matter. The caveat was filed because of further consideration, my lord. At times the young friends are over enthusiastic and there are professional considerations. So one may file a caveat. But fact of the matter is respondent 5 has no personal interest in the matter. I have only complied with the order of the state government. And my lord, pursuant to the order of the state government, there is an office order of 29th of April, which is not part of the record. 29th of April order, my lord, the petitioner, my lord, he was released. So that I place on record. And few points, my lord, I will clarify. He was released on 29th of April. Though, my lord Justice Pathak had given a stay to the order of transfer, but now, my lord, after the speaking order, it is taken in effect. And now here, my lord, they are seeking this stay. But, my lord, be that as it may, there are other issues I will clarify. First of all, my lord, so far as respondent 5 is concerned, my lord, I am the senior most, it is true. It is equally true, my lord, that I am eligible to be promoted to the post of executive engineer. Thirdly, my lord, a charge can always be given, my lord, to anybody. A person who is eligible to become executive engineer can be certainly given a charge temporarily to meet the exigencies of situation. There is nothing illegal about it. Again, though I reiterate, I have no interest. Government has directed me, I have complied with the order. Now, so far as my lord, other facets are concerned, lordship may just turn to the inquiry report, page 47 and 48. What exactly is in the inquiry report? Lordship, page 47, I will just point out certain things. Though it was read, I'll read it differently. Work execution findings. What exactly it shows? 1. The execution of electrification work for BSNL tower at such and such in Giba Circle under the Parijo Electrical Division deviated significantly from the approved DPR and work orders. Now, my lord, petitioner is an executive engineer. There is a great deviation in the work. Apparently, my lord, if the bribe was asked for or demanded, or whatever transpired so far as monetary facets are concerned, it is because of the nature of work. There is a relation between the two. And the committee has found this, number 1. Number 2, the work commenced on verbal instructions from the then executive engineer in charge and was executed as per the direction of junior engineer JE without proper documentation or adherence to specifications. Executive engineer can't be absolved of the responsibilities why these malpractices happened. Thirdly, the work orders were issued only after completion of the work, and discrepancies were found between the executed work and the approved PPR. Work were executed, work order came thereafter. So, my lord, there is a complete nexus which is there in the administration. And my lord, against this petitioner, there were serious allegations. There were serious allegations, and now my lord will turn to the speaking order itself. I will read para 1 to para 6. And my lord, before that, kindly in page 48 itself, what were the nature of allegations and what the committee found? Committee is talking about in its recommendation, the matter be referred for further investigation by an expert because there is some evidence. They are saying so far as the criminal case is concerned, expert evidence may be required naturally. For criminal case, my lord, expert evidence would be necessary. Then based on the forensic finding, that is again for criminal case. For departmental proceeding, my lord, we don't require this kind of evidence. Thirdly, appropriate departmental action may be considered against the officials responsible for the procedural lapses in work execution and on adherence to DPR specifications. Now, my lord, even if we take a departmental action, the competent authority has deemed it fit that the continuation of the officer there in the present situation may not be conducive for the good governance. That is the finding. Now, lordship may turn to below the speaking order para 1 to para 6. Para 5. Lordship will just para 5, page 71. Para 5. The concerned official was posted at Department Electrical Division as executive engineer by order dated 4/3/24, pursuant to which he joined the Department Electrical Division on 1/4/24. However, within a year of his posting, several complaints were made against him, labeling serious allegations of corruption and malpractices. So, here the competent authority is talking about lots of complaints against the person concerned. One such complaint dated 27/10/24 was made under the provision of Prevention of Corruption Act before the Superintendent of Police, Department District Upper Subansiri. Since the allegation attracted the provisions of the Prevention of Corruption Act, the concerned Superintendent of Police forwarded the complaint to the Superintendent of Police Special Investigation Cell, Itanagar, and as per the information received, the Deputy Superintendent of Police, SIC, while letter dated 14/11/24, asked for permission to register a regular case as the allegations made against the official were serious and required thorough investigation. Then, my lord, subsequently, para 6, another complaint dated 6/11/24 was made to the Deputy Chief Minister cum Minister Power, leveling serious allegations of corruption and malpractices against the officer. The matter was taken by the Department of Vigilance, which by its letter dated 18/12/24 asked the undersigned for comments on the complaint against the officer. Thereafter, the Chief Engineer Power Government of Arunachal Pradesh was asked to make a preliminary inquiry, fact-finding inquiry to ascertain the veracity of allegations based against the officer. Now, my lord has already seen the findings. So far as the preliminary inquiry is concerned, apparently, my lord, prima facie materials are there showing, my lord, malpractices here under his jurisdiction. Things have happened. So, my lord, it is under this circumstances, primarily for the purpose of ensuring good governance and to ensure that whatever other process which is to be initiated against him can be undertaken, my lord, he is being sought to be transferred. Now, transfer, my lord, is a condition of service. It is not a punishment. And in the present case, certainly it is not a punishment. It can't be said it is punitive in nature. Now, my lord, what exactly is the scope of judicial review? On the scope of judicial review, I will only place, my lord, the Govardhan law. Lordship may see. Why are you keeping it with yourself? My lord, I have got a loose copy. Lordship may see para 7 and para 8, the scope of judicial review.
No, that is a well set in respect of
But even that belongs to paragraph,
But the
because
question
here,
is,
my lord, number
no,
one,
Mr.
number one,
Tiwari,
my lord, is there a malice in law? Or is there a bona fide exercise in power? Against whom, my lord, bona fide has been alleged? Though the principle is well delineated in Govardhan Lal. Lordship, I just read once, para 7 and para 8. At page 406, Lordship may see.
Yes.
It is too late in the day for any government servant to contend that once appointed, para 7, that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary in the law governing or conditions of service, unless the order of transfer is shown to be an outcome of a mala-fide exercise of power or violative of any statutory provision, an act or rule, or passed by an authority not competent to do so, an order of transfer cannot lightly be interfered with as a matter of course or routine, or any or every type of grievance ought to be made. Even administrative guidelines for regulating transfer or containing transfer policies at best may afford an opportunity to the officer or servant concerned to approach their higher authority for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer or servant to any place in public interest, and as found necessitated by exigencies of service, as long as the official status is not affected adversely, and there is no infraction of any career prospect, such as seniority, scale of pay, and secure emoluments. This court has often reiterated that the order of transfer made, even in transgression of administrative guidelines, cannot also be interfered with, as they do not confer any legally enforceable right, unless as noticed supra, shown to be vitiated by mala-fide or is made in violation of any statutory provision. A challenge to an order of transfer should normally be eschewed and should not be countenanced by courts or tribunals as though they are appellate authorities over such orders, which could assess the niceties of administrative needs and requirements of the situation concerned. This is for the reason that courts or tribunals cannot substitute their own decision in the matter of transfer for that of competent authorities of the state, and even allegations of mala-fide then made must be such as to inspire confidence in the court or are based on concrete materials and ought not to be entertained on the mere making of it or on consideration born out of conjectures or surmises, and except for strong and convincing reasons, no interference could ordinarily be made with an order of transfer. Now, my lord, I simply submit number 1, there is no mala-fide exercise of powers. No mala-fide has been alleged, number 1. Number 2, it is not the case of the petitioner that the order of transfer has been issued by an authority not competent to do so. Number 3, it is not the case of the petitioner that there is a violation of the statutory provision. Number 4, my lord, no case of malice in law has been made out. There is the malice in law, I ask myself. So, my lord, basically here is a case, person is being sought to be transferred to Itanagar in the office of the chief engineer as a matter of good governance because there are serious issues involving the petitioner. That is the reason for which. So therefore, my lord, I submit, this is not a case wherein this writ petition should be entertained and it is liable to be dismissed. That's my claim.
I'll just give 2 minutes reply, my lord. First, my lord, my learned friend, government advocate says that this is not by way of punishment. Please come to page 37. My lord, we all know the transfer jurisdiction. We all know the hour limitations. We all know the limitation of your lordships to interfere. But we are only assailing the decision-making process. If there is, it's a case of malice in law. Where is the doubt about it? Page 37. How the file was initiated. As per order of the higher authority at note 150 above, file is resubmitted with proposal for transfer of N.K. Jha, executive engineer, from Dapurijo Electrical Division to the office of the chief engineer on the basis of public complaint and etc. And senior most assistant engineer may be taken. So, my lord, my learned friend Mr. Tiwari is beneficiary of a government order. Now, it is basically for the government to defend its order. Now, government has argued 2 points before your lordships. One, it is not that it's a punitive transfer or that any complaint was taken note of. That stands, my lord, qualified by this. Secondly, my lord, my learned friend, the government advocate, he relies upon some subsequent development. Well, a public order publicly made has to be construed in the context in which it is made. Now, there are 3 grounds taken in the impugn order of impugn order by which the representation was disposed of. One, that the inquiry committee has found prima facie guilty, which is not correct. Number two, my lord, since, my lord, the sending of a matter to the forensic for investigation is within the domain of police investigation, it has got nothing to do with departmental proceeding. And number three, my lord, the authority, because the earlier the learned single judge directed us to also submit a copy of the Somesh Tiwari's case, they have tried to distinguish Somesh Tiwari by saying, here is a case, there is a preliminary in court, and in Somesh Tiwari's case, there was no preliminary. No, in Somesh Tiwari's case also, there was a preliminary inquiry report. So therefore, my humble submission, and my learned friend Mr. Tiwari says, it's not a case of malice in law. It is a malice in law because you have purportedly punished me. In lieu of punishment, you have transferred me. That is why it is malice in law. That's my humble submission. And my lord, just I'll place the judgment, my lord. Mohinder Singh Gale's case, my lord. I'll just giving the paragraph. 1978, 1 SCC 405, para 8. Just small paragraph, my lord. Now they have given 3 reasons in the impugn order. Now my learned friend, the government advocate, he cannot supplement it by some other reason. That is what Supreme Court says. See, my lord. Para 8.
No, that is well said.
Yes. That's all. Para 8. Yes. So that is my humble submission.
You were referring to paragraph number
8.
Pardon?
Para 8. That Gordhan Judge Bhanji's case, my lord, AR 1952 Supreme Court, page 16, para 9, where Supreme Court said, Justice Vivian Rose said, my lord, public order publicly made has to be construed in the context in which made. It cannot be supplemented by a subsequent stand taken in the affidavit. Therefore, in MS Guild, in para 8, Supreme Court says, if this is permitted, then every case will become good by the time it comes to the court. Because at the time of passing the transfer order, only complaints were taken note of. And while passing the Milord order, rejecting my representation, 3 grounds were taken note of. And I have submitted my lord, all the 3 grounds suffers from the vice of malice in law. That is my case, Milord.
Only but not clarification on law.
Yes.
Pointer Singhil is not applicable because order of transfer is not in the nature of public order. It never was. It's an integral part of the service law, master and servant relationship. Public order concept in jurisprudence is entirely altogether different. Mohinder Singh Gill case is the case of election commission. That was a public issue. Here, public issue is not involved. It's purely personal to an individual order of transfer. No public order.
One clarification, my lord. The order I place, my lord will see, my lord, that is some order is before, my lord, the impugn order, my lord. This is those documents are part of the official record, my lord. It's not the case, my lord. This order was issued after transfer order, my lord. Now, my lord, will see in the impugn order, my lord, not only allegation of other complaint, my lord. So that was also part of the, I humbly submit, my lord, that was also part of the report before the competent authority while passing the speaking order. Because my lord will see, my lord, in the impugn order, my lord, or various complaints, not only against the corruption, my lord, other complaint is there, my lord. The order I place on record, my lord, is one is of January, my lord, where is a transfer of April, my lord. So I humbly this guild, my public subsequently that cannot be said placing the record, my lord, would be not applicable in this case, my lord. That is
okay. Heard Mr. Ken Sodhuri, learned single counsel assisted by Mr. Sharma, learned counsel for the petition. And Mr. Parme for respondent number.
Oh, sorry. State respondents. 1, 2, 3, and 4, Miller.
1, 2, 3, and 4. And Mr. Tiwari for respondent number 5.
it's for 5, my lord.
He's for 5.
6, 7, 8.
And my lord, I have joined in this place of posting only on 1st of May 24. I have not completed tenure also.
What
Of
is the
2 years.
tenure? Normal tenure.
2 years. Yeah, I have joined only on Miller 1st of May 2024. And that report, the allegations are which my learned friend read, that doesn't pertain to me, pertains to my predecessors. In charge, the then in charge executive, not me. I never gave this word. My lord, this is a ploy to put pressure on me to make the payment. That's nothing else. Just waiting for that to file a reply mail. It's a ploy, putting pressure on us, make payment or else we are going to blackmail you. This is what is happening.
Okay. Order reserved.
Yes, deep.
Met please, Lordship. Petition is SSC registered on the GST Act, my lord, Central Goods and Service Tax Act, my lord. Respondent number 3, my lord, initiated an investigation with regard to non-payment of around 5 crore 79 lakh rupees. The Lordship will find it, my lord, page 17, my lord. Someone is there, my lord. The Lordship will find it.
Page number?
Page number 17, my lord, annexure B. Page 17, my lord. 17.
So you have filed on a representation before
Yes,
the authority
yes, that is
for
pending.
allowing you to make payment by installments.
Section 80 of the CGST Act provides in the power, my lord, to allow me to make payment in installments, my lord.
Is there any provision in the act?
Yes, section 80, my lord.
Okay,
I have also quoted in the petition, my lord.
okay.
My lord, I'm appearing on behalf of the respondent number 2 and 3, my lord.
Respondent number 3.
2 and 3, my lord. So the copy has not been served upon me, so I need some time to instruction, my lord.
Appearing, my lord. They are total, well,
No, the pair is simple that they have acknowledged their amount, but their pair is that they may be allowed to make payment in installment. Oh, under which provision?
section 80, 80 of the Central Goods and Service Tax Act, my lord.
Yes,
Yes, ma'am.
18.
At 80, my lord. 80.
Yes,
Payment of tax and other amount installments, my lord. May I read, my lord?
yes.
On an application filed by a taxable person, the commissioner may order reasons to be recorded in writing, extend the time for payment or allow payment of any amount due under this act, other than the amount due as per the liability of self-assessed in return by such person in monthly installments not exceeding 24, subject to payment of interest under section 50 and subject to such condition and limitation as may be prescribed. Now, this amount is not self-assessed in the return, my lord. They have quantified it, my lord, and we have admitted it, my lord. Out of 5 crore, 1 crore we already paid, my lord. The
Pardon?
balance out of 5 crore 74 lakhs, 1 crore we have already paid, my lord. Remaining is 4 crore 74 lakhs. That we want to pay installments, my lord.
So the remaining amount,
Yes, my lord.
4
crore 74 lakhs, my lord.
293.36.
My lord.
So this amount has to be paid within in how many installments?
My lord, they have the power to grant 24 installments, my lord.
Pardon?
They have the power to grant 24 installments, my lord.
24.
Installment as per section 80, my lord. They can consider my application and they may allow me to make this payment in 24 installments, my lord.
So let us do one thing. We dispose of this petition by directing the respondent authority
My lord.
to dispose your representation
Yes, my lord.
in terms of section 80 of the
CGST Act,
CGST Act.
my lord. And my lord, till then, my
Yes,
lord,
Mr. Boru,
My lord.
you
so
dispose
it will
of their
be-
representation.
My lord. Yes, my lord.
For Mr. Mr. Learned Counsel for the petitioner and Mr. Boru for respondent number
2 and 3, my lord.
2 and 3.
2 and 3, and Mr. Kato for 1,
Respondent number 1.
respondent number 1.
Lordship, I'm also appearing for 2 and 3 also. That,
Okay,
yes.
your name, please?
T Kipa.
Deepa and
Yes.
Mr. Boro for
Yes,
the
direction,
respondent number 2.
directed by the Commissioner of CGST.
Okay. Mr. Boro, learned counsel for, Mr. Mishra, learned counsel for the petitioner submits that the petitioner is an SSC registered under Central Goods and Service Tax Act 2017, bearing registration number 1, 2,
Page 14, madam.
ZPD
My lord.
5633M1ZR and has been discharging his liabilities of payment of GST, etc., as and when fell due. Mr. Mishra submits that the petitioner was apprised by the respondent authorities about GST liability of the sum of rupees 5,79 lakhs 31,327.26, and the petitioner, now out of the said amount, the petitioner has paid a sum of rupees 1 crore 5 lakhs 31,034 rupees. And there is balance of balance amount of rupees 4 crore 74 lakhs 293.26 rupees. And he is being pressurized to make immediate payment of the balance amount. And also he is threatened with coercive action if the aforesaid amount is not paid immediately. Mr. Mishra submits that the petitioner is not in a position to make payment of the entire amount in one go, and that he has filed one representation before the respondent number 2 on 26/5/2025 for allowing him to deposit the balance amount in installment, but the said representation failed to evoke any response. Mr. Mishra also submits that Section 80 of the Central Goods and Service Tax Act, Central Goods and Service Tax Act 2017 provides that the payment of tax and other amount may be made in installment. And in that view of the matter, the respondent authorities may be directed to dispose of his representation dated 26/5/2025, keeping in mind the provision of Section 80 of the CGST Act. Mr. Boro, learned counsel for the respondent number 20, submits that he has no objection in the event of disposing of this petition with the aforementioned direction. Mr. M. Kato, learned counsel for the Deputy Solicitor General of India for respondent number 1, submits that any objection? No objection. Submits that he has no objection in disposing of the aforementioned petition. No, in disposing of this petition with the aforementioned direction. But having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also peruse the provision on the peruse Section 80 of the CGST Act 2017. Section 80 of the Act of 2017 read as under. Vote it. Taking note of the submission of learned counsel for both the parties, and also in view of the provision of Section 80 of CGST Act 2017, this court is inclined to dispose of this writ petition by directing the respondent authorities to dispose of the representation dated 26/5/2025 within a period of 2 weeks from the date of receipt of certified copy of this order by keeping in mind the provision of section 80 of the CGST Act. The
My lord,
petitioner shall
may I pay
obtain,
it maybe
yes,
3 weeks, my lord, can it be?
3 weeks. Okay, all
My
right.
lord.
3 weeks. Uh, the petitioner shall obtain a certificate copy of this order and place the same before the respondent authority within a period of 1 week from today. In terms of above, this petition stands closed.
I have a small prayer, my lord. Till disposal, there's not any coercive action against me, my lord. Till disposal of representation, my lord. Because it is under
Is
consideration.
it necessary?
Lord
No,
will observe, if Lord will
no,
observe, my lord,
That's not necessary,
if
Lord.
Lordship, it will not harm to them. Otherwise, I will be difficult if they
Okay,
proceed.
okay, the till disposal of the representation dated so and so, the respondent number 2 shall not initiate any coercive action against the petitioner.
Deeply obliged, my lord.
Obliged.
Where, my lord? I have taken the instruction, today we are going to, my lord, take up the tender issue, my lord. The tender will be finalized, yes, today.
Today.
Yes, my lord. The officer concerned was out of station for some training purpose, my lord. So he has joined, my lord, so today there will be a decision. my lord.
Okay, you will list the matter tomorrow then? You apply this for tomorrow.
Can it be day after tomorrow? Because if it is
No,
not today,
it
but
is,
then tomorrow, my lord.
6 June is approaching, no?
Yes, my lord. So, my lord, today is 4, my lord, 4 June, my lord.
4th of June.
Yes, my lord. My lord.
Okay. Heard, Mr. T. Goram, learned counsel for the petitioner, and Mr. Pisha, learned standing counsel for the respondent authorities. Mr. Pisha submits that the respondent authorities are proposing to finalize the tender matter today.
Yes.
And as such, he pressed for listing the matter on 4th of June 2025. Pair allowed, raises a list the matter on 25th or sorry, 4th of June
My lord.
2025.
Deeply obliged.
May I appreciate
Very sorry that on Friday, my lord, not able to appear before your lordship for instruction. In that IDCL matter, my lord, in the matter.
Yes.
In that matter, my lord, in fact, I communicated to the matter IDCL for communication. My lord, really honest. They returned my lord, they informed me about the matter, the status of the case. Rather, they told us that my lord, they have engaged one counsel. So therefore, the counsel for the respondent number 1 does not have to do anything. my lord. So there is no matter on that day, my lord, I could not able to appear before you.
Oh, all right. We have passed the order.
But yes, man. But difficulty is, man, in most of the department.
No, but the question is, question was, the dispute is private dispute.
Correct.
So whether the petition will be maintainable, that has to be
Yes.
seen. But there is one letter issued by the respondent number 2 to the respondent number
Yes, sir.
3.
Only they, my lord, they informed me.
So therefore, we have kept the question of maintainability
But-
open.
Just they inform us that, my lord, no, they have their own counsel, so therefore
all
nothing to be worried about. That was the, my lord, therefore, my lord, I could not able to appear on the day. But now, my lord, here in this case also, my lord, before starting the case by my friend, well, since matter is already pending before the, my lord, the appropriate authorities, the disciplinary inquiry, my lord, anything, my lord. So therefore, my lord, this is a premature stage. This is stage, my lord, no. We have filed additional, my lord, the detailed affidavit, my lord. In this case, my lord. So therefore, my lord, this matter can be disposed of by, my lord, by using the record and everything, my lord. Otherwise, my lord, this is premature stage.
It is?
Premature stage, my lord. if lordship peruse the order pass initiated by the department, that is
Page number.
page number affidavit filed by the department is page number 31
No,
Annex
the
5.
question is, you have already initiated proceeding against
Correct,
them
ma'am.
and imposed punishment.
Correct, ma'am.
Then is there any scope for second disciplinary proceeding upon the same subject matter?
He is not raising that issue, Malad. He is raising that only for the claiming of the payment pension and other service benefits.
Yeah.
Yes. So that will be decided once that disciplinary proceeding is completed.
No, that issue has been raised by them in this petition also.
Yes. Last communication, the charts.
You see the pair being made in the page number 16 of the
Yes.
petition. They have also challenged the
16,
yes.
Page number 16 of it.
Yes. They are paired.
This is Malad's first one.
Yes, first one and also the second one.
Second one is not Malad mentioned specifically. Second
Interim
one is
disciplinary proceeding initiated by memorandum of article of service on 18/9/2020.
but latest one is Malad the 21st December 2022, Malad. Affidavit filed by the respondents.
Where is the affidavit?
21st December 2022, man. And this has been communicated, Malad, forwarded to the petitioner on 23 December 2022. Page number, Malad, 54 is the Malad forwarding letter, man. 54, man, Annex 13.
Yes.
And on receipt of this, Malad, they have not even communicated, Malad. The matter is pending before the authorities concerned. And there is no Malad, even Malad, the affidavit in reply to that aspect. Sorry, Malad, reason that they come. Absolutely.
So there is the first inquiry report was not accepted by the authority.
Malad.
And there was a disagreement note. Where is the disagreement note? Is it part of the record?
Malad, that may
Page
not be.
number 54, Annex 13.
That is not Malad, the annex one.
You see, this disagreement note bearing memorandum number so and so dated 21st of December 2022. That disagreement note is not part of your affidavit.
No, Malad. last person, my lord, page 53, my lord. Now therefore, I series says so and so, retired, is given an opportunity to submit his representations within 15 days of the receipt of the memorandum against the above points of tentative disagreement with the following findings of the IO. It is in case his response is not received within the stipulated period, the decisions will be taken as per records available without waiting for his reply.
So, you have received the letter? This letter?
This memorandum, page number 52, my lord.
54,
54.
annexure 13.
Yes, received, Your Honor. And same is replied on my rejoinder also, Your Honor. Very crystal clear. Since from the petition till the rejoinder, I very much clear and properly mentioned and properly sequence wise clearly mentioned that this is very fit case, very genuine case, and very disrespect and disregard regarding the respondent authorities to, without any proper evidence, without any proper issues, problem, I just suffer so much. Entire my family suffer, Your Honor, this irregular kind of the code of conduct and whatever it is, Your Honor. Because since from the CPL labor which died 28 November 2018, whatever the police inquiry investigation is completed, none of the single point is against me. Yes, I am the guilty of this offense. Police give the clean sheet. Then after court of inquiry conducted, the court of inquiry very crystal clearly mentioned that I am no any proof mentioned against me. What are the 3 articles is framed against me, Your Honor? Not proved. Entire allegation very crystal clear. I'm totally free and no any accusation against me, Your Honor. Till that, for this purpose, the MO, the Minister of Defense took the time of the 3 years, more than 3 years, to giving any solution, any conclusion. We waited since from 2021, Your Honor, till that 5 years almost completed. Then no any proper solution gave to the authority, Your Honor. Since from the petition and rejoinder very clearly mentioned what are the allegation, accusation gave the respondent authority against me. Like the allegation is not corrected. What are the articles, what are the charges against me, Your Honor? Since from the code of conduct, starting from the memorandum, I already proved that the page number. First of all, Your Honor, may look into the page number 28, Your Honor, in my petition.
28.
28, Your Honor, in the petition, Your Honor. First of all, Your Honor, what are they just presume that there is some mistake, unethical, what of the misconduct has happened from me, Your Honor, they give the performance counseling. This is a kind of the punishment which comes under the CC Act, which I clearly mentioned in the Honorable Court that they already took the steps against me, that I am doing some act and I'm not like raising upon that particular performing counseling, Your Honor. Then after they're not satisfied, then this act, they go the second double jeopardy action, that the code of conduct steps their side, Your Honor. After this month, the inquiry conducted framing 3 articles. Number 1, whether I am the CPA labor, which died 28 November 2018, I deployed for domestic purpose in my home. Secondly, through the master role, I just manipulated the officer of J to role absent, present to absent, Your Honor. Second thing is that the concerned driver who opposed to driving the official car of mine, Your Honor, on that regard, that particular person is driving the car of my domestic car for doing the domestic work, like for my wife, my domestic purpose work, my child work, Your Honor. But none of the articles were the proof against me, Your Honor. Neither the police investigation gave any accusation against me, clear the final report and clean sheet to me. Then after the court of inquiry conducted, Your Honor, and this court of inquiry conducted in between the 20 to 2021, and then after 2022, they submitted that I have no any issues. All the allegations are no any against me, Your Honor. I am free from everything. Then after they are not satisfied, then they send to the MOD regarding some no satisfaction regarding this matter, Your Honor. In their reply, Your Honor, they mentioned that and they sent to the MOD. And till that, Your Honor, since from the 2022 December, Till date, Your Honor, no any single reply yet to be received, Your Honor. It's very disappointed regarding the date. Since from the 2020 till date, Your Honor, 5 years completed, Your Honor, me and my entire family suffered regarding the regular pensions and all the losses.
You were receiving provisional pension.
Yes, Your Honor. Between this problem, Your Honor, my wife also suffered the cancer. So many mental trauma. I also suffered some mental trauma also, Your Honor, regarding this matter. To pay the counseling fee, advocate charges, regarding the whatever their problems going on. Yes, yes, Your Honor. Yes, Your Honor. May I look into the matter, my lord? Page number 85 to 24, Your Honor, in rejoinder, Your Honor, in mine. 85 to 124. 124. My lord, regarding the page number 100, Your Honor. This is the page number 100 to 101. Just come in the sequence by my lord.
100.
Page number 100 and 101. This is the first article charges that I deploy the CPA labor to my domestic purpose at my home in absence of my wife and children. So this allegation was clearly not proved by the Court of Conduct inquiry by the presiding officer. What is the eye of the case, Your Honor?
That's correct, but from the page number 54, it appears that there is one disagreement note. That note is not part of the record. It means that this finding of the
Yes,
of
sir.
not proof is not accepted by the authority.
But my lord, without any
See
Yes.
page number 54
page number 54.
of their affidavit in opposition.
Yes, Your Honor.
Then where is the additional inquiry report, Mr. Kato?
Yes.
It is mentioned in this letter.
Malad, as per the record, Malad, this is Malad till the proceedings held and by framing Malad memorandum of charges and article of charges, Malad.
No,
21st.
you see, here
After
it is
that, madam,
mentioned along with copy of inquiry report and one copy of additional inquiry report.
madam,
Yes.
Where is that report, additional inquiry report?
additional inquiry report, madam. Departmental inquiry under, so. Madam, it seems it is not, madam, enclosed. It is not enclosed. madam. After this, madam, what happened, madam, that inquiry report has been from the affidavit in reply, madam. There is no correspondence, madam, from the department. After this, madam, the latest charge. Thereafter, madam, from the record is transparent, transpires that this is the, madam, on the report, inquiry report, madam. The what the petitioner is relying upon, madam. Page number, madam, if I read again, madam, of the affidavit in the reply, madam, filed by the petitioner.
Page number?
Page number, madam, 100, and madam, the starting page is. It is only inquiry report, madam. Now that, madam, is department inquiry, madam, again disciplinary authority, again that will go to the, madam, the approval authority, madam. There is a, madam, the hierarchy of the authorities.
No, that's all right. After submission of this inquiry report, the authority has not accepted the same.
Madam.
And therefore, this is disagreement note.
Yes, madam.
And there is also one additional inquiry report.
Madam.
But these are not part of your
Madam,
affidavit.
in that case, madam, this is prior to, madam, the affidavit filed by the, madam. After that, madam, there is no correspondence, madam. So may I take the, madam, at this stage, madam, may I take instructions on the additional affidavit one? The particularly, madam, what type of additional inquiry has been?
Yes. Within 1 week or 2 weeks?
2 weeks, madam.
No, 1 week. The person concerned already retired.
Madam,
His
the
wife is
allegation,
suffering from cancer.
madam, what department is doing is, madam, madam, the allegation is very serious, madam. One person has died on, madam, out of the record, madam, that is, so that is the only, madam, the.
No, died all right, but as per this inquiry report, the charges are not proved.
Madam, take me,
No criminal case. Criminal case was registered, inquiry was made, police submitted final report.
Yes.
madam, allow me to take instructions on that particular aspect. madam. Within a week, madam, I'll take it.
Pardon me, sir.
M. Bagra.
M.
M. Bagra, my lord.
M. Marak,
Bagra. BAGRA.
learned counsel for the petitioner, and Mr. M. Kato, learned Deputy Solicitor General of India for respondent authorities.
All respondents, madam, please.
Mr. Kato, learned counsel for the respondent authorities, submits that right annexure 13 at page number 54 of the affidavit in opposition filed by the respondent authorities. One disagreement note dated 21st of December 2022, along with a copy of inquiry report and one copy of additional inquiry report, was sent to the petitioner for submission of representation within 15 days from the date of receipt of above memorandum. But the aforementioned disagreement note and also the additional affidavit referred to in the letter dated 23rd of December 2022 is not part of the record. In order to adjudicate the dispute raised in this petition, perusal of the aforesaid disagreement note and also the additional inquiry report is found to be necessary, and accordingly it is provided that Mr. Kato, learned counsel, learned Deputy Solicitor General of India, is directed to furnish the copy of disagreement note and the additional inquiry report by filing an additional affidavit before this court within 2 weeks from today
Madam.
without fail. List after 2 weeks.
Madam, develop.
Much obliged.
You have received the letter that memorandum?
Yes, my lord.
You have received the letter?
Addition memorandum.
Yes.
Not yet. If the receipt, then definitely I give the reply, Your Honor, in my written.
Are you sure this is 54 you have not received?
54 page number. 54 page number addition and same is replied on my rejoinder also, Your Honor.
You have submitted your reply to the authority?
Definitely. Rejoinder already submitted, Your Honor. Reply already in my rejoinder. The copy already served to the opposite party. Responding authority. Sir.
Then what order has been passed upon the same?
Not yet. Till that pending, Your Honor. No any single letter, no any information till date received. We are eagerly waiting.
Therefore, my lord, the pendency is one thing, my lord. The pending before the authority concern is another thing, my lord. So therefore, it is not yet finalized by the my lord. So once therefore, my lord.
So you obtain instruction in that respect also?
Yes, sir.
The learned counsel for the petitioner submits that in view. The petitioner has received the aforesaid memorandum dated 23rd December 2022 and he has submitted his reply to the aforementioned memorandum and the respondent authority has not taken any decision upon the reply submitted by him. Mr. Kato is also directed to obtain necessary instruction in respect of the present status of the reply submitted by the petitioner person to the FWD of memorandum dated 23rd of December 2022. List after 2 weeks.
Much obliged.
No, Your
Yes.
Here, all the respondents have filed affidavit in opposition except land management. On last occasion, they have seek time. If they don't
Land
want-
management.
Yes.
Which land management?
Lordship, earlier they had a standing council, now I'll be representing the.
You are?
Yes, Lordship.
So why you have not filed the affidavit?
Also appeared in this matter, Lordship. Already Deputy Commissioner has filed the. Will. Go by this affidavit, because they had a standing council earlier, Lordship, of course, we haven't taken press instruction again. If they are going to file or not, Lordship. We have already filed. Deputy Commissioner has.
If land commissioner don't want to file, then it may fix for here hearing. It may be fixed for hearing if land management don't want to file the affidavit of the issue.
Reply.
Yes.
You will file your reply.
No, Your Honor, Your Lordship. If land management don't want to file their affidavit in opposition, then may fix for the final hearing. Yes, because it's been long they are seeking that as Somo.
Learned counsel for the petitioner and Madam G. Ite, learned additional senior government advocate for the respondent number.
Earlier, I was for 4-5. Respondent number 4-5.
Respondent number.
1 and 2 also.
Respondent number 1, 2.
Yes, sir.
3, 4.
6, 7, and 8.
6, 7, and 8. And Mr. Respondent number 9. Respondent number 9. The learned counsel for the petitioner, referring to office note dated 31st of May 2025, submits that counter affidavit has not yet been filed by the land management department. Land management department. Ms. Ites, learned additional senior government advocate, submits that the the deputy commissioner has already filed the affidavit and she has to obtain instruction as to whether the land management department will file their affidavit or not. Accordingly, it is provided that registrar shall raise the matter after a week. So as to enable Ms. Ite to obtain necessary instruction in respect of filing of the affidavit, counter affidavit by the land management department. In the event of failing to obtain necessary instruction in this regard, registrar shall raise the matter for final hearing.
Merge.
This item number 6 and 7, my lord, department want some more time to find out.
Okay. But it appears that the matter is pending 2022, since 2022.
Yes. Last time they had committed, other development has come up
Acha.
in the local.
Hmm.
So in addition, I think they want to find.
Additional.
Additional, they find the appeal, but there is an appeal.
Okay.
Some more time will be granted.
Okay. Heard Mr. K. Lolan, learned counsel for the petitioner, and Mr. R.S. Nabam, learned AG, additional AG for the state respondent. Mr. Nabam submits that the respondent authorities have already filed their affidavit, but thereafter some new development had taken place, and the said development are required to be placed on record by way of an affidavit, additional affidavit, and he tries for granting 2 weeks or 1 week.
At least 3 weeks, madam.
Three-
Department name was for 4 weeks. madam.
No, this matter is of 2020.
Yes, madam. 3 weeks, madam.
No objection. Okay. 3 weeks time. Mr. Kato, you are for
Madam, I am from the Union of India.
respondent number?
For the number 1 and 2. madam.
Respondent number 1 and 2. Okay. List the matter after 3 weeks.
Lordship, there is an interim order that may.
Interim order, pass earlier, continue.
Deeply obliged.
Number 8, इसलिए तो हमने क्लिक कर रहे हैं.
Your Lordship, I on behalf of my senior counsel, actually busy in another court of your honorable bench. So the matter may be listed
After
2 weeks.
2 weeks. Heard, Mr.
T. Roland,
Learned counsel appearing on behalf of Mr. L. Parmay,
permits.
learned conducting counsel for the petitioner, and
And my
also
lord-
heard Mr. R. R. Koyo appearing on behalf of Mr. Learned standing counsel for education department. T. Tagum for education department. Learned counsel for the petitioner. Learned counsel appearing on behalf of Mr. L. Parmay, learned counsel for the petitioner. Price for listing the matter after 2 weeks. Fair allowed, recess
And my lord,
after 2 weeks.
there is an interim and.
Okay, interim order pass earlier shall continue.
Number 11.
May I please, Lordship? Lordship, in item number 11, we need to file rejoinder, Lordship.
Rejoinder.
Yes, Lordship.
Mr.
T. Darren.
T.
T. Darren, Togge Darren.
Learned counsel for the petitioner.
Yes, Lordship.
None appears for the respondent not called. The learned counsel for the petitioner submits that the petitioner will file rejoinder affidavit to the affidavit in opposition. And price for listing the matter after
2 weeks, Lordship.
after 2 weeks. Fair allowed recessal is the matter after 2 weeks.
Obliged.
Your Lordship, as per last order, we have served we served to respond number 4 by AD.
You are for? Five. Heard Miss
Yes, Somo.
Learned Counsel for the petitioner and Mr. Learned Counsel for the respondent number 5. On behalf of Titi Tada. No, respondent number 5 is already struck up from the array of this petition.
Yes, Your Honor.
None appears for the rest of the respondents. Office note dated 26/3/2025 indicates that notice upon respondent number 4 is affected by the same mode, and an affidavit to that effect has also been filed by the Learned Counsel for the petitioner. But no one entered appearance on behalf of respondent number 4. Yes, it's a list the matter. After 1 week. In the event of non-representation of the respondents, respondent authority, the appropriate order shall follow. List after 1 week.
Much.
Well, this is land acquisition matter.
IA is for what purpose?
My lord, there is a perjury. Perjury has been committed by the respondent. 1, 2, 3, and 6. I go correct. My lord, the page number, para 5. My lord, in their affidavit, they have given false information before this honorable court, saying that the total area that they have taken over from the Assam Raipur was not 187 acres. In fact, there is a record that they have taken over 187 acres.
Where is that document?
A document, my lord. Page number 43, my lord. This is next, this is not so clear, so type copy is 44. Page number 44. शुरू कर दिया.
Sorry for the interruption. I am appearing for on behalf of BHA.
On behalf of M.
Marto
Yes, yes.
For respondent number 123. Due to some personal difficulty, please the permission
Just before this
But
matter,
you could have, he could have mentioned the matter.
that could have been done earlier.
But due to some personal difficulty, just now we did.
Day after tomorrow then?
Well, I will leave for 0 today.
Today?
So let us have on 10th.
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 Okay.
Otherwise, my lord,
in
we
spite
can-
of this document, they have filed.
They have said they have not
Acquired.
in possession of 187 acre. This document says that 187 acre was taken over from the Assam Rifle by the ITPDP. And they have also made clarification. Next page. Somewhere 1.87 was mentioned in a letter. And that has been clarified. It is not 1.87, but 187. Next page, madam. So
This is the letter of deputy commissioner. No.
ITBP.
Commandant.
ITBP commandant has written to the deputy commissioner.
Admitting that it is 187.
Yes, madam.
And in their affidavit, they have denied.
Saying that they have not taken over 187 acre. This is a clear case of perjury, my lord. And again, they have said that the measurement taken by the district administration for acquisition of 19 acre, that measurement was not taken by equipments which is required to be done by that equipment. And therefore, the acquisition process, the sketch map and the acquisition process for 4 crores compensation, that has not been accepted, it says. But there is no document showing that that has been not accepted. Accepting the measurement and the assessment made by the district administration, sanction was accorded. So at least in 3 occasions, they have committed perjury, madam. Otherwise, we can have tomorrow, madam. I will cancel my going back to 0. We can have it tomorrow.
Tomorrow?
Tomorrow.
Yes, you asked Mr. Kato to remain present tomorrow. Heard Mr. S. Koyam, learned counsel for the petitioner, struck applicant, and also heard N. Sora, appearing on behalf of Mr. M. Kato, learned counsel for the respondent number 1 and 2, and Madam P. Songita for respondent number 4 and 5. 4 and 5. You for 6 also, ITBP. 6. And Songita for 4 and 5. Mr. Sora submits that due to some personal difficulties, Mr. Kato left the court premises. And as such, he tried for standover of the matter for the day. Where is accordingly allowed to list the matter tomorrow.
All legal.
Matter pertaining to principal suit for delivery of order, item number 124, bill application number 1625.
Lordship. Lordship is not
Yes.
audible, Lordship.
Yes, yes.
Yes, now Lordship is
You are
audible.
audible. Yes, yes.
Lordship, item 1 was not audible, Lordship.
Yet to be delivered.
Okay, Lordship.
Wait for a while. I am signing it. All the bail petitions allowed.
Please, ma'am.
Yes.
Well, so far, no respondent has not responded. Filed a counter affidavit, and the last occasion government has short the time. Now, my lord, I came to know that in response to the step taken upon the private respondent.
Yes.
Now, my lord,
We'll need 3 weeks time.
3 weeks.
At least, yes.
and in the meantime, I will also file my lord one IA. Because
for?
in response to the my lord, step upon the all private respondent, it's come to know that respondent number 8 and 5 is no more. Therefore, my lord, I have to file the
Implement of legal hairs.
Yes, legal here, my lord.
Huh? When did you file it?
My lord, I will file it this
Oh,
morning
you will
only.
be filing.
Yes, I'll be
Okay.
filing within
Okay.
1 week.
Heard Mr. Modi, learned counsel for the petitioner, and Madam Sangita for
1, 2, 3, and 5.
1, 2, 3, and 5, and Mr. A lawyer for respondent number
4 and 6 also, Union of India.
4 and
6.
6, and Mr.
7, 8, sorry, 7, 9, 10, 11, 12, 13, 14.
Your name, please. Ms. Sangita, learned counsel for the respondent number so and so submits that she may be granted 2 weeks time to file her affidavit in opposition. And you? Our affidavit is not required, so we are
Required.
not going to file our.
And Mr. So-and-so submits that the affidavit of the respondents being represented by him is not necessary in this case. And your affidavit? You will file. And the learned counsel for the respondent number so-and-so submits that he may be granted some time to file the affidavit in opposition.
Yes, my lord, I admitted this wrongly, my lord. This respondent number 7 has been repeated as respondent number 16. So this respondent number 16 be strike of my lord.
Okay. Respondent number 7 and 16.
16 only.
16.
Yes.
No,
Because
7 and 16 are same person.
yes, 7 and 16 is the same
Okay.
person.
Mr. Modi, learned counsel for the petitioner submits that out of mistake, respondent number 16 is implemented here in this petition, and he has already been implemented as respondent number 7. And as such, the name of respondent number 16 may be deleted from the array of this petition. Further, Mr. Modi submits that respondent number
8 and 15.
died.
Yes.
8 and 15.
8 and 15.
8 and 15 suffered demise, and as such, he will file an application for implement of the legal heirs of the aforesaid two respondents. And he prays for granting him some time. Here is accordingly allowed. This is the matter of sir. 3 weeks or 4 weeks?
2 weeks for me. No problem, 2 weeks.
3
2
weeks,
weeks.
zero.
3 weeks.
3 weeks. Okay, 3 weeks.
All right.
Offline.
My lordship,
Ah,
lordship, today itself we received this IA.
Pardon?
Yes, my lord, this morning we have filed an additional affidavit to bring on record a judgment.
it is not pleasant record.
No, Your Honor. It's about the additional ground out of those 9 grounds that we have. Lordship, we need a 3 weeks time to file a counter They are affidavit. seeking time to file a reply on that.
3 weeks time.
Yes, lordship.
Heard, Mr.
KUB,
Learned counsel for the petitioner and Mr.
Titato.
Learned counsel for the respondent.
Yes, lordship.
The learned counsel for the petitioner submits that he has filed an additional affidavit.
Yes, Your Honor.
Additional affidavit taking some new grounds. In addition to
9 other grounds.
ground number 1 to 8.
1 to
Ground
9.
number 1 to 8.
9. We have
No. In addition to 1 to 8,
We have 9 grounds, Your Lordship. 9 grounds, Your Lordship.
you have taken.
Yes, we have taken a ground 1 to 9. Yes, we have submitted 9 grounds, and in additionally, yes,
In addition to
9
9
grounds.
grounds
Yes,
mentioned in
yes,
the petition.
yes, Your Lordship.
The learned counsel for the respondent submits that he may be granted 3 weeks time to file a reply to the additional affidavit filed by the petitioner. Where is accordingly allowed, this is unless the matter after 3 weeks. Okay.
Deeply obliged. Deeply obliged, Your Lordship.